So friends, a federal judge just ruled that a defamation case, a lawsuit brought against Donald Trump, will not be dismissed. Rather, it will move toward trial. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, Donald Trump is being sued for defamation by 5 wrongfully convicted and fully exonerated men, previously known as the Central Park 5, now known as the Exonerated 5. And Trump was desperate not to have to go to trial. He filed a motion seeking to dismiss the case, have it thrown out in its entirety. Well, a federal court judge just ruled that the case will not be thrown out in its entirety. Let's start with the new reporting. This from MSNBC. Headline, Judge rules Trump can't get rid of Central Park 5 defamation lawsuit. And that article begins, President Donald Trump lost a bid to dismiss a defamation lawsuit brought by plaintiffs known as the Exonerated 5, formerly the Central Park 5. Thursday's court ruling brings Trump closer to a trial and to potential civil liability for comments he made about these 5 men, during a presidential debate against Kamala Harris last year. But it doesn't guarantee that the plaintiffs will ultimately succeed in their case. Trump's history with Yusef Salaam, Raymond Santana, Kevin Richardson, Antron Brown, and Corey Wise dates back decades. They were teenagers in 1989 when they were charged with attempted murder, rape, and other crimes after a woman named Patricia Mealy was attacked while jogging in Manhattan's Central Park. Before they were indicted, Trump took out a full-page newspaper advertisement, not naming but clearly referring to them, calling to bring back the death penalty, bring back our police. 4 of them, not Salaam, confessed, then recanted their confessions and maintained their innocence. They were all convicted of at least some of the charges. Years later, a different person confessed, and indeed, DNA evidence confirmed that confession, and the convictions of the 5 men were vacated in 2002. Trump has continued to question their innocence over the years, leading to last year's debate with Harris that sparked the lawsuit. After the Democrat brought up the Republicans' newspaper ad calling for their execution, Trump said, quote, they admitted, they said, they pled guilty. And I said, well, if they pled guilty, they badly hurt a person, killed a person ultimately, and if they pled guilty, then they pled, we're not guilty. Rejecting Trump's motion to dismiss, U.S. District Judge Wendy Beadlestone wrote that it can be plausibly inferred that Trump had sufficient knowledge of plaintiffs' wrongful conviction and exoneration to have understood that plaintiffs did not plead guilty. Nobody died as a result of the crimes that day in Central Park, and plaintiffs are indeed not guilty. So friends, let's go through just a little bit of the judge's opinion so it's crystal clear what went on here. In the case of, I'm going to call them the Exonerated 5 plaintiffs versus Donald Trump defendant, memorandum opinion. During the 2024 presidential election cycle, then candidate and now president, defendant Donald Trump faced then candidate and then vice president Kamala Harris in a televised debate hosted by the National Constitution Center in Philadelphia. At the debate, defendant Trump made certain comments about the Central Park Five, a name which for decades has been used to refer to the five plaintiffs. Based on those comments and several others that Trump made about plaintiffs over the years, plaintiffs brought this lawsuit alleging 1, defamation, 2, false light, and 3, intentional infliction of emotional distress, all under Pennsylvania law. Defendant Trump now moves to dismiss the complaint in its entirety. And then the judge reviews just some of the evidence. Initially, plaintiffs denied any connection with the assaults and the rape. Yet after hours of coercive interrogation and without an attorney present, 4 plaintiffs, Santana, Richardson, Brown, and Wise, eventually confessed to both the assault and rape. Plaintiff Salam never confessed. Plaintiffs quickly recanted their confessions, but the criminal process had begun. Plaintiffs were indicted and charged. Each of them pleaded not guilty and maintained their innocence throughout the trial and for the years that followed. And yet, they were all convicted. About 12 years later, in 2002, one Matthias Reyes confessed that it had been him, not any of the plaintiffs, who had committed the crimes. The Manhattan District Attorney's Office reopened its investigation into the assaults and, given Reyes's confession, as well as DNA evidence that corroborated that confession, all plaintiffs' convictions were vacated and the indictments dismissed. And let me add here, friends, that the Exonerated 5 brought suit for wrongful conviction against the City of New York, and the City of New York settled. Against that backdrop, here is some of what Donald Trump said that prompted this defamation suit. Quote, "There's never been anything like it. They're destroying our country, and they come up with things like what she just said, going back many, many years when a lot of people, including Mayor Bloomberg, agreed with me on the Central Park Five. They admitted, they said they pled guilty. And I said, well, if they pled guilty and they badly hurt a person, killed a person, ultimately, if they pled guilty and then they pled we're not guilty." So after relating that stream of rambling nonsense from Trump, the judge turned back to the plaintiff's claim. Plaintiff's interpretation of defendant Trump's comments is that the comments asserted 3 key propositions. The first is that plaintiffs pleaded guilty. False. The second is that plaintiffs badly hurt someone. False. And the third is that plaintiffs killed someone. False. And then after an analysis of the applicable case law and the arguments of the parties, the judge's conclusion: for the reasons set forth above, defendant's motion to dismiss shall be denied as to plaintiff's defamation claim. Because plaintiffs have plausibly alleged actual malice, defendant's motion to dismiss shall be denied as to plaintiff's false light claim. And friends, let me add that with respect to the third count or the third charge in the case, intentional infliction of emotional distress, the judge concluded that there was some technical deficiency in the way that charge was pled by the plaintiffs, so the judge dismissed it, but the judge dismissed it without prejudice and gave the plaintiffs the opportunity to correct that technical deficiency and refile that third charge. So no, the case was not thrown out in its entirety. It ultimately will survive in its entirety, and it will head toward trial. But friends, the question you may be asking yourself is, well, wait a minute. Can a president be forced to go to trial in a civil lawsuit while he's president? And doesn't he have some kind of immunity? Let me take on those questions. The answer is yes, a president does have some kind of immunity because the Supreme Court justices, some of them, made up presidential immunity from whole cloth. It's not in the Constitution. It's actually contradicted by the Constitution, but the president does have immunity from criminal prosecutions, not from civil lawsuits. So the presidential immunity ruling from the Supreme Court doesn't apply to this civil lawsuit. And then the second question is, well, can he be forced to go to trial while he's president? The good news is the answer is yes, because that issue was settled by the Supreme Court in the case of Jones versus Clinton, where the Supreme Court ruled that for conduct that a person commits prior to becoming president, he can be sued and he can be forced to go to trial even while he is serving as president, with the rationale being, defending oneself in civil litigation, in a civil lawsuit like defamation, doesn't require that much time. It doesn't really interfere with the duties of the presidency. The president doesn't even have to attend the trial. Remember, he's been sued civilly in other cases where he didn't attend and he lost. But the good news is, yes, this case can proceed to trial even while Donald Trump is serving as President of the United States. So friends, when this case does make its way to trial, let's hope that the jury gets it right, and I suspect they will, because contrary to what Donald Trump told the nation during a presidential debate, the Exonerated Five did not plead guilty. The Exonerated Five did not hurt anyone. The Exonerated Five did not kill anyone. So Donald Trump, at the end of the day, should be held accountable for his defamatory statements. Because justice matters. Friends, as always, please stay safe. Please stay tuned. And I look forward to talking with you all again tomorrow.